standing here this afternoon with Tora Michelle, as you know, the city legal attorney, and then next to him is Colleen Petty, who's also one of our fine attorneys with the city of Houston. And then we also have Alexis Agames, who is with the city's public affairs department and worked very closely with Bill Kelly and my team in Austin throughout the entire legislative session. As you know, during the 88th legislative session, the state legislature passed House Bill 2127, known as the Death Star Super Preemption Law, filed by Representative Dustin Burrows and Senator Brandon Creighton. The bill was signed into law by Governor Greg Abbott on June 14th of this year to take effect on September 1 of this year. Since this bill was introduced, I, along with members of City Council, have been sounding the alarm on the dangers of this legislation and its efforts to strip local governments of its authority. It is no secret, for years the legislature has been eating away at local control and governance. But House Bill 2127 has gone way out of bounds. It is extreme, and I don't think that is an overstatement. Under House Bill 2127, preemption is given a new meaning, and one that effectively repeals Texas constitutional home rule. And the city of Houston is a home rule or general law city, which means that via the Constitution, we've been given the power of self-governance. House Bill 2127 purports to preempt all local regulation under Texas agriculture, finance, insurance, labor, natural resources, property, business and commerce, and occupations codes, unless explicitly authorized by the legislature. What this means is that cities like the city of Houston cannot pass ordinances in these areas unless the state of Texas explicitly gives us permission to do so. That is a total reversal from the way things have been in this state for more than a century. This attack goes against many new ordinances that council has approved, ranging from regulating tow truck companies, outdoor music festivals, payday lending, after-hour establishments, noise regulations, boarding homes, and so many others. Under House Bill 2127, preemption is given a new meaning, and one that effectively repeals Texas constitutional home rule. Moreover, it disregards the hierarchy of Texas laws, where a statute such as HB 2127 cannot repeal a constitutional provision. Our laws require a constitutional amendment election to effect a repeal. And to give you an example, I spent 27 years in the legislature, and if you were going to pass a law that repealed or superseded the Texas Constitution, you would pass a constitutional amendment as well as the general law like House Bill 2127. In this case, what the Texas legislature has done is that it has passed House Bill 2127 as a state law, but it has the direct impact of repealing portions of the Texas Constitution. That is a non-starter. Constitutional local control gives Texas cities the power of self-government, permitting them to tailor their laws specifically to address local residents and business needs and desires. Well-established Supreme Court decisions place the burden of proof on the party challenging a city law to establish a direct and irreconcilable conflict with unmistakable clarity of preemption. There's not a conflict here. What the state of Texas legislature is attempting to do is to carve out whole sections of laws and saying to cities, you cannot venture into these areas unless we give you express permission. And so as we move forward into the future, cities like the city of Houston would know what areas that we can govern unless we find it explicitly laid out in state law. House Bill 2127 creates a one-size-fits-all statewide regulation scheme with no attempt to address areas of concern that prompted cities to pass laws in response to constituents' requests. Programs like Houston Pay-or-Play programs for city contractors, which provide 30,000 uninsured Houstonians with health care, would die under House Bill 2027 as we move towards the future. Or the most popular one nowadays, Dallas and Austin ordinances that mandate water breaks for workers in the Texas heat will simply go by the wayside. The Texas Constitution expressly champions the local control and innovation that has been key to the tremendous economic dynamism in cities like Houston. House Bill 2127 reverses over 100 years of Texas constitutional law without amending the Texas Constitution. As local elected leaders, we know the specific issues of our city and residents and should have the proper tools to address those issues head on. What is true for Houston is different than that of Dallas or San Antonio or Lubbock or any other municipality in our large state. Therefore, Houston will fight so its residents retain their constitutional rights and have immediate local recourse to government by filing suit against the state of Texas, the Death Star super preemption law. Let me yield now to City Attorney Arturo Michelle.
Thank you, Mayor. I think the Mayor covered what is we believe is very clear in the law, that Texas does not have a scheme like the federal government. We do not have a supremacy clause. We have a primacy clause. For over 100 years, and before then, what would happen at the beginning of the 20th century and the end of the 19th century, the legislature dealt with hundreds of bills that localities wanted. It changed the law in 1912 so that you had home rule, which is not field preemption. There are not areas that are covered. You look at a law, if it's challenged, if it is a direct, irreconcilable conflict, and the intent is clear, it's manifestly clear that it was to be preempted, that's when you apply preemption. The Mayor's covered most of the things that need to be discussed about this. What I would like to point out is how this is going to work in practice. The city of Houston, like all cities, even the smallest home-ruled cities, have a lot of ordinances, laws on the books, in addition to a charter for home-ruled cities. We have to examine all of those laws and try to determine if they're covered by these 8 fields that are in the bill. Then once we do that, we have to look elsewhere in state law to see if, despite it being covered, we're somehow given the express ability to proceed with that. That is very time-consuming, and this bill has flipped the burden of proof again on its head. Before, someone would have to challenge an ordinance. Now, if we enact an ordinance and are challenged, we could be liable for the cost of that litigation. That's a very, very heavy burden, and even more so than the financial and time-consuming burden, it robs the city of Houston of the ability to act quickly when it needs to, particularly in times of disasters, or to prevent disasters. Certain things that we would do in the areas, for example, of drainage or flood control may be preempted, and we may be challenged. And there may be people who suffer because we are not able to do what the Texas Constitution allows us to do, which is local government to act quickly to address the needs of its residents.
Thank you. At this time, we'll take any questions if anyone may have. And the lawsuit has been filed already. Yeah. The lawsuit has already been filed, and it was filed in Travis County. Okay. Any questions? If not, okay. Thank you so very much.
Thank you.